until yesterday morning. And
That's
I
right.
think you found out who the judge was going to be at the end of last week. So thank you very much.
Quite frankly, I don't know who the judge is going to be. But a couple of things, Sean. I mean, you're certainly entitled to your opinion as to why I'm doing what I'm doing. Quite frankly, no matter what I say to you is not likely to convince you because your mind is set, and I respect that. But good. The 1,500 signatures on the petition, there weren't 1,500, there were 1,100, of which 500 of them were declared invalid. So you had a good number, 600. But while Judge Currier did rule, I didn't interrupt you. Judge Currier did rule initially that the petition was fine, as written, but then indicated that there needed to be some clarifying language placed on the interpretive statement on the ballot so that the lack of clarity that was in the two questions that were based on, that were posed on the ballot could be cleared up. That's my interpretation of it, and you may very well disagree with it. And not only did the ward-based question not get on the ballot because of lack of time, because you ran out of time, but because the judge also granted a motion for reconsideration because of some questions that were raised with regard to her decision, which apparently had merit and got her attention. Now, I'm not saying which way she would rule, but which she felt were credible enough that she ought to set this down for another hearing and reconsider her prior decision. Notwithstanding that, for whatever reason, the petitioners decided to abandon their first petition, which apparently they didn't think was flawless, and came in with another petition. This one signed by less than 300 valid signatures, but enough to normally get on a ballot. The question became whether or not, and I agree that an issue is the Charter Study Commission ordinance adopted by the council called for an election to happen in 2008. Obviously, that time had passed. That's a real issue that the court's going to have to make a decision on if that's what we ask the court to do. On the other hand, there's a theory that only one of these can go on, it's not a theory, it's the law, only one of these can go on the ballot at a time, and the first one that goes on, the first one in is successful and trumps the other. So does the naming of a November 2008 date negate the decision to have a charter study in the wake of the withdrawal of the initial petition by the petitioners? I don't know the answer. So, you know, you're free to interpret all of that as however you choose to. And just like you're free to let this run to the court and let the judge make the decision. And I'm perfectly fine with that. Let's get somebody back. Yes, sir. George and then the fellow in the red shirt.
Yeah, George Dawson, probably well in place. It's in the second ward. And the fourth ward.
I'm sorry, George, I didn't hear that.
George Dawson, 12 Llewellyn Place.
Hi, George.
It's in the fourth ward. First of all, I support your proposal to have forums on these charter questions. I've been trying to get a forum going on these charter questions for about a year now, and haven't been able to find a venue courageous enough to take it on. So I think you're doing. I think he's an idiot that we should have these discussions. Second of all, I was disappointed. Some of you may know I supported the charter change 13 years ago, and was disappointed that the Charter Study Commission didn't recommend any change. But I see the major issue that should be looked at in a charter change is the question of nonpartisan elections. We've had partisan elections in this century, in the last century, since 1970, and there had only been 2 elections in which there have been major contests. One, the first one in 1970 with Ralph Mulick, and again in 1974 with Richard Mulligan. Most of the time, there's no real contest on the ballot. And I don't know why the Republicans don't put candidates on up for election. That's their decision. I don't understand it, but there's never a contest. And I think the way to, I think it's I think a major issue should be looked at is the nonpartisan elections, having made elections.
Right.
The question I have, though, if a charter change question is on the ballot in November, and it's approved, of course, that it goes into effect, if it's defeated, isn't there a waiting period for about 5 or 6 years before you consider another charter change?
There is a period of time before you can change within that area of question. So if you go to wards, you cannot undo wards for a period of, I think it's 4 years.
But suppose the question is defeated. The charter question is defeated.
I'm not sure of the answer to that, George.
Okay. Because I thought there might be a delay, and therefore, if you want to push for a nonpartisan system, you wouldn't be able to do it for another 4 or 5 years. So,
I think because a nonpartisan system, and again, we could get answers to these questions that are definitive, but my best thinking is that a nonpartisan form is not precluded if we go forward with wards, because it's a different category, it's a different subcategory of the different options that are available to forms of government. Okay? But before we take the next, and the fellow in the red shirt, just 1 second. Sean, back to you. You indicated before in the Charter Study Commission that it was done a number of years ago and that you recommended no change and that the public didn't have the opportunity to participate or vote. You're right that they don't get a chance to vote on the recommendation of the Charter Study Commission. They do get a chance to participate because it's a 9-month process and they're all public meetings. So they get to weigh in as much as they choose to or not. And then lastly, the one thing they do get to vote is whether or not they want to do the charter study, and secondly, who the commissioners are. So you're right in the end result. Sure. Yeah. Mm-hmm.
I think the problem is if you have it, you have commissioners be elected at large. That's not helping. It's not helping the problem.
That's a valid point. Yeah, valid point. Yes, sir.